We see a lot of our customers here, and we owe them a debt of gratitude, because without them we wouldn't be able to provide these tremendous seminars for free. And so that's really, really great. And also, our HR customers often say that they're heroes in their organizations. They send us thank you notes every day. And you can be a hero too. They use us for executive and leadership coaching, as well as outplacement coaching. And I just want to let you know that we're very different from other organizations and very affordable. So let me just tell you a little bit about executive and leadership coaching, which I don't normally talk about. First, pricing. In the old days, outplacement was priced ridiculously high. 15% of a person's prior W-2. 15% of a person's prior W-2. It made no sense. It bore no relationship to the service that you were paying for. The same thing is true with executive and leadership coaching today. We hear about enormous packages, $30,000, $40,000, and there's no relationship between that price and what you are getting for the money. Our goal-oriented programs are priced from $5,500 to $13,500, which you might say, well, it can't be a very good program. No, trust me, the 5 O'Clock Club delivers the best programs out there. But it's a rational price. It does bear some resemblance to what you get. At those prices, we're working with everyone from CEOs, yes, down to first-line managers, and we're even selling some reduced packages for important administrative assistants that the companies want to have coached. I mean, what we're having is a lot of our coaches going into one organization, coaching a lot of people, because at those prices, organizations can afford us. So I have to tell you, nobody else has these prices. Let me describe a little bit about the service. When you hire us, you hire a team. See, our programs are different. They're research-based. When you hire us, you hire a team. Our senior coaches work very closely together. They all know each other, and they turn to each other for guidance. We want them chatting with each other. We actually have conference calls with all of the executive coaches. After the primary coach has worked with your employee for 4 or 5 hours, that coach then must turn to a peer review coach and say, here's what we've done so far, here's what my plans are, give me your feedback. And they've all worked with each other for years, and so that's not a problem. Who else has a peer review approach? So that you don't wind up with these weirdo coaches out there acting like cowboys doing whatever they want. You know what I'm talking about, the ones who come in and just sit and chat for an hour every week, and it's like, what are you getting done? Anyway, nobody else uses this collaborative peer review approach. Also, our coaches use a consistent approach. It starts with goal setting, then the coach assesses the coachee to determine what other issues might there be that should be addressed. We have our reference text, Navigating Your Career, which you'll get when you leave today. It's basically a reference text. It does not guide the coaching, but it saves a lot of coaching hours, because the coach can say, why don't you read this and talk about it next time, or whatever. Nobody else has such a consistent approach among their coaches, because most of the coaches out there, even if they work for a major outplacement or executive coaching firm, most of them are independent coaches doing their own thing. We also provide with a written report, provide you with a written report, mid-program and end of program, and we have flexible scheduling and responsiveness according to the needs of your employee. So, look, things come up. Sometimes our coaches have to talk to a person in the evenings and weekends. Guess what? That's what our coaches are supposed to be responsive, and they are. So we have an affordable program, a peer review process, a team effort, a consistent yet flexible approach, and responsiveness to your needs. So, like, what are you waiting for? Just use us for leadership coaching and executive coaching. On the outplacement side of the business, we're very, very different, but I'll only tell you one thing. Half of those who attend the club are self-referred. Half of those who attend are self-referred. Who wants to be around a bunch of outplacement, downsized people who are moaning about the economy and how bad things are, and the outplacement firm doesn't care about them? And guess what? They'll be gone in 3 months or 6 months anyway, so good luck with that. We want those self-referred people there. We charge them all very little, but it's a healthier environment to have self-referred people mixed in with the people who are sent by you. Nobody else does that, because we're doing what's in the best interest of the employee. And by the way, our recent research, as of last week, professionals, managers, and executives who regularly attend the small group get jobs in half the time of those in the population as a whole. Population as a whole, Bureau of Labor Statistics says 30 to 35 weeks, depending on people over 55, people under 55. Our job owners in this horrible market are taking, to be honest to God truth, 16 weeks. It's normally 10 to 12 weeks. Okay, they're taking 16 weeks on average in this market. That's remarkable. Half the time that it's taking the population as a whole. Okay, enough about that. Our next meeting is going to be on September 9th. The topic is best practices in employee engagement, retention, and succession planning. You will get your invitation next week. You'll get the notice about this meeting, the video, as soon as it's available, which normally takes a week. Thank you for coming, and thank you for allowing us to be part of our your professional lives. On with the main event. Here we have moderators, and there we have the panelists. Jerry Capelli and Andrea Briscoe are both former HR executives, and both are 5 O'Clock Club executive coaches. They are today's moderators because we figured it would take 2 people to handle today's panelists. I want to personally thank Jerry for putting this whole program together. Take notes. You have a notepad in your folder so you can follow along. The speaker's handouts, the incredible speaker's handouts, are also in your folder right behind the gold directory. And that's it. Take it away, Jerry and Andre.
Good morning. I have a kind of exciting opportunity to introduce our panelists this morning. And as Kate said, I do have kind of a combination background of working in HR and also being what I call now a recovering lawyer. With that, I have a lot of respect for our panelists. And I'm also very excited to co-moderate this with Jerry Capelli. So before we move on to the questions, I'd like to say that I've also had the opportunity to work both with Bill Maloney and with Greg Wigdor, and what's important in lawyers, both of them truly possess, and that is integrity, zealous representation, and also making your client feel valued. So those are great things. On the employer side, we have Bill Maloney from Epstein, Becker & Green. He is the vice chair of his firm's board of directors. He heads the international labor and employment practice, and he counsels, advises, and teaches. On the employee side, we have Greg Wigdor from Thompson & Wigdor. And he is a former clerk of the Eastern District, former ABA as well. Also part of the Best Lawyers and American Super Lawyers peer review, so that's wonderful. And he also is currently representing the victim in the Dominic Strauss-Kahn case. So without further ado, we'll start the...
First question is for either one of the panelists. What legal developments have caused the 8% increase in EEOC retaliation claims? Do you see this trend continuing? If so, why?
Thank you, Judge. Sure, why don't I get started? I think there are several factors here, frankly, legal and non-legal, that have led to this extraordinary increase. And it is extraordinary. From 1964 through 2009, since Title VII was passed in 2009, every single year the most often filed charge of discrimination with the EEOC was race discrimination. A better and more consistent record than the 27-time world champion New York Yankees had in the same period. For the first time in 2010, retaliation charges were the most often filed. And I think, as I say, there were several factors there. In terms of some of the non-legal factors, the terrible economy. I was on the phone with the EEOC yesterday in a matter we're working on, and they are absolutely swamped. And the investigator commented that inevitably, in a difficult economic time, when unemployment rates are high, adverse employment actions taken, employees laid off, you see an increase in all charges, in all claims of discrimination, those with merit and those without. I think one of the other factors at play here, and Doug may differ on this, and this is the cynical side of it. Certainly there are genuine claims that are filed, to be sure, but I also think that employees are increasingly sophisticated about their rights. There are very talented lawyers representing employees, counseling and advising them, and oftentimes now we see, I think, as a tactical move, someone complaining of some form of discrimination and harassment in advance of an adverse action being taken against them, which will create the possibility then of a retaliation claim being made. So I think that's a factor as well. Perhaps, though, the most important factor, and what I think really has driven the numbers more than anything, is the very liberal interpretation of what retaliation means under our laws by the courts. And the biggest of those cases, I think, has been the Burlington case decided by the Supreme Court. And without torturing you, all of you, more than I need to, very, very simply, the elements of a retaliation claim are that an employee must demonstrate they engaged in some form of protected activity. They complained of some form of discrimination or harassment. They filed a charge of discrimination with one of the agencies. They made a claim internally as well, of course, as I mentioned. So there's that protected activity. Then it's necessary for the employee to demonstrate that there was adverse action taken, that there was some form of adverse action taken as a consequence, that there's a causal relationship then between their protected activity and that adverse action. It had long been the position of most courts, and certainly of employers, that the adverse action had to be something substantial, a material impact on the terms and conditions of someone's employment. So, for example, a demotion, a salary cut, a termination, a significant effect on the terms and conditions of employment. In the Burlington case, the U.S. Supreme Court rejected the notion that it was necessary for there to be an adverse impact on the terms and conditions of employment. And instead, in Burlington, and I will just read, I think, what is the most important quote in that case, according to the Supreme Court, the law of the land now, an adverse action is an employer action that could dissuade a reasonable worker from making or supporting the charge of discrimination. Anything. Anything that would dissuade a person from filing the charge. Anything that would dissuade a person from engaging in protected activity. So the examples the court gave, inviting an employee to lunch, a manager inviting an employee to lunch or not, could be an adverse action if, for example, that lunch might be an opportunity to talk about assignments or engage in some training. A change in scheduling where perhaps the employee involved has childcare-related responsibilities and shifting by 30 minutes or an hour that person's schedule would make that person less likely to complain. I think that more than anything has really driven the increase. And another part of that decision, the Supreme Court said, context matters. And that's an invitation for these cases to be disputed on their facts. And when there are factual issues, courts will not dismiss these cases short of trial. Summary judgment motions will fail. So bottom line, the employer knows going in that Doug is going to manage to get in front of a jury with these cases because we're not going to be able, in all likelihood, to get them dismissed short of trial. And now you're in front of a jury, and you've got a plaintiff making a claim of discrimination or harassment and alleging that they were retaliated against for having made that claim. Under our laws, the employer can prevail on the discrimination claim. The employer can prevail on the harassment claim and still lose on the retaliation claim. And in fact, that's exactly what we see happening. The percentage of victory in retaliation claims is far greater than the underlying discrimination or harassment claim. And we talk to jurors after they render verdicts in these cases. We're permitted to speak with them if they're willing to talk with us. We always take advantage of the opportunity to learn what we did right and what we did wrong. And what they tell us, and what's most challenging where retaliation is concerned, we're human beings. And the jurors will say to us, it just didn't seem credible. It didn't seem reasonable when that employee accused his or her manager of sexual harassment, that person did not have it out to get that person, that did not factor into decisions that person was making. So in addition to the lessening, if you will, of the legal standard, we also see the greater likelihood of success because jurors, I think, can sympathize more with that employee making the claim, given human nature. I do think as well, the second part of Jerry's question, do we see that trend continuing? And I think the answer to that is certainly yes. The New York Times today, the one page of the business section of the Times, reported that Wall Street firms are about to undergo another round of job cuts over the summer. So more terminations, more litigation. Let me, if I may, turn it to Doug for some comments. I'm sure he has on it.
Perhaps we need a chest talk here.
Wasn't I nice? Wasn't I polite?
I agree with a lot of what Bill has said. I certainly wouldn't call the Burlington Supreme Court case a liberal interpretation of what retaliation is. I think it was the correct interpretation of what retaliation actually was supposed to protect, which was acts after somebody complained in good faith about sexual harassment or discrimination from an employer taking steps to dissuade somebody from actually reporting discrimination and or harassment. That certainly is up there, I think, in terms of why we see so many retaliation claims being filed. I think there are a couple of other things I see as well, though. One is, I think that there have been quite a few large verdicts out there in the retaliation field. And unfortunately or fortunately, there are a lot of plaintiffs' lawyers out there as well, some of whom never practiced employment law before, and some of whom may be personal injury lawyers or doing something else, and now see this as an opportunity to sort of cash in the employment field. And so I see a lot of lawyers dabbling in employment law and filing retaliation claims. I think that has a lot to do with the increase in the number of claims as well. And certainly, with respect to the large verdicts, I've tried many cases where we have an underlying sexual harassment claim or an underlying discrimination claim, and we don't prevail on that, and we do prevail on the retaliation claim. And Bill's right. I mean, the main reason for that is jurors can relate to retaliation claims. They're somewhat skeptical when somebody claims discrimination. Obviously, these things happen, but people walk into the jury box thinking, well, I'm not really sure. But when they hear about a complaint that's made in good faith, and they start to see all sorts of actions that were taken after, then I think the jurors are much more inclined to award the plaintiff in a retaliation claim. The other thing is that we also have to be aware, the question was about the increase in EEOC filings of retaliation claims. We also have to be cognizant that there are retaliation claims filed, for instance, under Sarbanes-Oxley with OSHA, and we're seeing a lot of those as well. And we're also seeing retaliation claims being filed with the Department of Labor on wage claims, where people are retaliated against for wage claims. So we should be cognizant of that as well. In terms of it, whether this is going to continue or not, one thing that we're seeing more of, and it's been in a lot of the different periodicals that Bill and I read every day, is and there's been a recent Supreme Court case about it, is the use of arbitration clauses in employee handbooks or employee policies. And while that certainly would not impact the EEOC, because it's impermissible to ask an employee to waive their right to file a charge with the EEOC, what we're seeing now are more policies that cover discrimination and retaliation and attempt to force those cases into the arbitration context. Employers seem to think that's a good idea. I can tell you 2 weeks ago I got a $24 million verdict in arbitration, so maybe it's not such a great idea. but that's something also to note in terms of the increase in these sorts of claims.
You can hear me, yes? All right. To kind of drill down a little bit more from both of you, what types of retaliation claims are you seeing? What sort of acts or omissions would constitute retaliation?
Well, we're seeing a lot of different types of claims. I mean, obviously, they're the basic retaliation claims. Somebody complains of sexual harassment or discrimination, and they're retaliated against. But given the new Supreme Court standard, we're no longer having to prove, and I say we, plaintiffs' lawyers, are no longer having to demonstrate that an employee was terminated or demoted. So we're seeing more claims where, for instance, a person is isolated. Maybe their office has changed. Maybe they're not given the same sort of client opportunities. Maybe they're put into a different position at the same salary, but a position that is sort of a dead-end position. Not being invited to social events with clients. So we're seeing a lot of those sorts of claims for retaliation. There was also a new case which extended the retaliation claims to third parties. So, for instance, I have a pending claim in the Southern District now where there was a gentleman who was the CEO of an environmental remediation firm, and his daughter worked for the company as well. And he complained of age discrimination, and he was terminated, as was his daughter. His daughter has standing now because of this new Supreme Court case, and so does he. So he can claim retaliation not only based on the fact that he was terminated, but we're also claiming that he was retaliated against because his daughter was terminated. And she has a claim that she did not admittedly engage in any protected activity. She never complained of age discrimination. She's a young woman. But she has a claim as well because she was terminated as a result of her father complaining of age discrimination. So we're seeing those sorts of claims as well. And it's really opened up, because of the Supreme Court's liberal interpretation, to use Phil's word, it's really opened up a lot of avenues to put these cases in court. And as Bill said, and it's right, these cases are very, very difficult, not impossible, very difficult to dismiss on summary judgment, which is the point after the discovery is taken right before trial. And once you get to trial, I mean that's a losing proposition as an employer because everything's going to be in public unless you're in arbitration, and you never know what's going to happen at trial.
I again agree. As Doug said, I think we're seeing with the post-Burlington decision, we're seeing allegations of too much work, too little work, being ostracized, things that might seem quite subjective, quite frankly, and very frustrating in terms of trying to defend those claims. As Doug said as well, we see courts expanding the third-party retaliation claims now that we're seeing in the wake of the Supreme Court case, making clear that that's protected. One of the things as employment counsel we've been batting over the head with for several years is the importance of background checking and the need to do that and be stringent in your background checking to avoid claims of negligent hiring and the like. And one recent trend that's been challenging, and we've had several calls from clients on this, you do your background checking, and what turns up in addition to whatever criminal and credit information is the fact that somebody has sued a former employer for some form of discrimination. And now your management is very concerned about bringing such a troublemaker aboard who likely will cause you similar difficulty. Well, the fact that that person's claim, the fact that that activity was against a former employer, still confers upon them retaliation protection. In other words, you can be sued in the event you would not hire someone because they engaged in protected activity, even with a prior employer. And we've had several of those cases, and it can be quite difficult. And the other quick point before Doug hits the chest button on me, any of you from New Jersey, any New Jersey folks brave the weather? Well, you've got one wacky state, I think, in some and we find that they tend to be quite more pro-employee in respects than New York does. But a decision coming out of the New Jersey Supreme Court last year, the Quinlan case, actually involved an HR person who was claiming sex discrimination. She said she was passed over for promotion in favor of a male colleague. And to make a very long, tortured story short, she was pursuing her claim while still employed. During the course of that claim, she copied some 1,800 documents that she had access to because of her role in HR and shared those with her counsel in prosecuting her claim. One of those was the performance appraisal of her now manager, the fellow who got the job that she says she should have had. When the employer learned that she had taken these documents in pursuit of her claim, it fired her. And she made a claim of retaliation. She succeeded. She won. And the reason she won, and I'm glad I hear some surprise, the reason she won is that the court concluded that the employer had more likely terminated her for pursuing her claim rather than for taking the documents. Now, I find that to be, on the employment, the management side, a very, very difficult decision. I think even EEOC has long taken the position that to be protected activity, the activity must be reasonable and appropriate, and not disruptive or otherwise contrary to company policy. So, again, I hope that case might be something of an aberration, but that is the extent to which, as I say, some of these retaliation claims can be so difficult.
This question is for Bill. Well, maybe not, seeing how you both like to talk. Given how difficult these cases are, they sound almost impossible to defend from the employer side. Aside from doing the background checks, what other advice would you give to employers confronting personnel issues surrounding retaliation?
I think that this trend really has impacted the advice we give. I think it's fair to say from the standpoint of employment advice, we have long counseled employers, you must engage in some best practices around personnel decision making. So be prepared in the event of a claim to articulate legitimate business reasons for what you're doing. Be prepared to demonstrate that you're acting consistently, that if you're firing someone for tardiness, for example, that you're not permitting others to be tardy and not acting differently with respect to the person making the claim. Lastly, the importance of documentation, communicating with employees and documenting those communications. I must tell you, my experience has been in court, to the extent that something is not written down, very often it didn't happen. And a talented plaintiff's lawyer like Doug, my friend on the same side of the table here, will absolutely tie you in knots. If you don't have documentation confirming what it is you've done and why you've done it, I think he can put you through your cases very quickly. So the documentation is crucial. The only other observation I would make, and this is I don't mean it to be a negative one, but I must tell you, as a practical matter, retaliation cases can be won from direct evidence. You know, a smoking gun memo that says, fire this person, he or she's a troublemaker. Well, that's direct evidence we lose. We can also see retaliation cases succeed where there is just circumstantial evidence. And the two things that are most important there, courts will tell you, are the timing. A termination or other adverse action soon after protected activity, they view as suspect. And to the extent that the decision makers were aware of it, that 1-2 punch can be difficult to defend. So what I'm sorry to say to you is, where it used to be my advice, and it still in many cases is, of course, to warn someone who's not performing and go through a process of trying to help them meet the expectations that you have. When I have those discussions now, I must tell you, I am counseling employers, be aware to the extent that you start that process. If that employee walks into your office a week or a month later complaining about some form of discrimination or harassment, your risk of termination, your risk of discipline is going to be much greater. So ironically and unfortunately, in some respects, this great wave of retaliation cases is leading employers maybe to act more swiftly to terminate where someone doesn't seem to be meeting expectations.
I just want to comment on documentation. I think that's a two-way street, to be perfectly frank, because some of my best cases have involved lots of documentation, and it's very easy to pick holes and to sort of use the documentation to your benefit. It's in fact, in virtually every case I've handled where there has been a lot of HR documentation, no offense, but it's been really easy to use to our benefit. So, you know, it is a two-way street. I think, when I think of documentation, what I think is useful is to make sure that, I'm talking prior to any complaints of discrimination, that you are doing regular, candid, frank, honest assessments and reviews. I can't tell you how many times we have cases where somebody's terminated, they've been at the company for 20 years, and all their reviews are excellent, and all of a sudden, you know, after they complained, they became a horror show warranting termination. And so the steps that you need to do in terms of documentation, I believe, are things that are completely unrelated to claims of retaliation, but are just best practices for you to make sure that employees know where they stand. And to be honest, I mean, it's not easy to sit down with an employee and tell them that they're not doing a good job. But that's something that you need to be doing and documenting, because the lack of documentation on that front is really very, very difficult to overcome. And the other thing is that you need to be, I think you used the word, Bill, and it's right, you need to be consistent. Consistency is very important, because if somebody complains of harassment or discrimination, and all of a sudden, you start searching all of this person's emails in an effort to find, maybe that the person sent some sort of an off-color joke or used some sort of pornography. I was doing a mediation a couple of months ago, and the defense team, in the middle of the mediation, said, showed the mediator, your client, my client, had viewed pornography, and the mediator, without missing a beat, one of the most experienced mediators in the country, said, who doesn't have pornography on their computer? and said to the defense attorney, said, did you search all of the other people's computers to find out whether they have pornography on their computer, the people he's accusing of discrimination? And the answer, they didn't answer, but the answer is obviously no. So they were singling this person out to try and find after acquired evidence to sort of muddy the water. So, you've got to be consistent on that.